important thing in your life at this moment. Do you understand? Okay. I'm going to grant you a limited PR bond right now. Anything else, if I find that you drive, I'm going to lose my shicer. Do you understand? You are not allowed to drive. I don't care what it is, where you're going, who for. You're not allowed to drive for Amazon. You're not allowed to drive for anyone. Do you understand? And if I find that you do, you're looking at a year in jail. Do you understand? Okay. I will grant the PR bond now. I'm sending you to test, and then I want him back here tomorrow so we can craft a plan going forward.
Understood. Thank you, Your Honor.
All right. Wow. Come on up.
Good morning. Well, almost afternoon. How you doing today?
Man, so great to see you.
Look, Judge, it's good to see you. You know, I don't normally come down here.
We welcome you. Really. It's just been too long.
It has. I saw you the other day. I tried to get your attention. You were coming. Who were you walking with? Looked like y'all were coming from lunch. May have been coming from Tree Beers. I'm not sure.
Wow.
But
You have something with us?
I do. I have a fugitive matter.
Okay.
So Ronnie Lewis is on docket today, Judge. Even though he's from here, apparently got stopped by a state trooper for a matter out of Louisiana. He missed his arraignment date. My understanding was they were recalling that warrant there, but Madam Prosecutor checked, the warrant is still active. So I'm asking that he get a bond so he can make that arraignment court date. I just was advised that the state is asking for no bond.
And here's the thing. I've given him a bond before. It's not my first rodeo with him.
Oh, yeah. Well,
And
we got those cases taken care of, though.
I know, dude's dangerous, man. I mean,
Judge, these are none.
robbery.
Well, the robbery is actually, I'm on the robbery. The robbery is going to be hopefully dismissed because he didn't do that.
Guys, do you mind bringing out Mr. Lewis? So just hold on. Let's bring him out so he can, because it's only fair that he gets to hear this.
Like I heard somebody.
You know I love you.
Yeah, no, I understand, Judge. You got to do your job.
This is a third. How many fugitive cases has dude had?
I've seen 2 prior ones here, Judge.
I remember one out of California. We got that taken care of. I think that matter was disposed of. Might have been dismissed. I wasn't on it, but now we obviously have this one out of Opelousas for, I think it's possession of marijuana and
So you're just saying obviously possession for methazine and then money derived from drug sales.
the old money laundering case.
You also had a prior fugitive for a robbery case on the as well.
It should show one.
Oh, that was the other one. Yes.
How you doing? Lewis, you know, I'm bringing you out here now because we're talking about you, and it's only fair that you get to hear what we're talking about.
Sir.
I will tell you that nothing in life makes me more unhappy than having to keep someone in custody. I don't like to put people in jail. I don't get off on it. There are a lot of judges that do, you know. I don't like it. And if I can keep someone out, then I try, you know, because jail sucks. But some people get it and just some people don't get it, you know? And while I really don't know you, the way I get to know you is how you are on paper, because that really tells me who you are. Are you a nice guy? Are you a danger to the community? Do you hopscotch criminality with the states like you're playing hopscotch? Not
Ain't never went.
anymore.
Yeah. Oh, there's been.
And look, I don't want you to say anything because I know that you're going to tell me it's little bunnies jumping in the woods, right? It's little rainbows and gumdrops and this, but this is the third fugitive case we had. I will tell you that I absolutely love your lawyer. I mean, just, but with a third fugitive case,
Take care.
not only that, you have an open robbery. You done now just picked up a burglar of a motor vehicle here, not
They just,
Well, they filed it today.
yes, sir. As a result of being in custody, it was a case from January, but just filed today. We did get a bond on that, but
You scare me. You really, really do. You know, you look young too. That's probably the worst part about this. I mean, what are you, like 26, 27 years old? You know, 32. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22. And that's just here. I really hope that it doesn't take a 50-year or a bullet to help you realize that can't keep it up. Something's gonna happen, man. You know, I can't. It's a
Understand.
third. You want to say something? I'm happy to hear you out.
I would, Judge. I do understand the court's.
This is a classic Bond argument. Nonviolent charge, showed up voluntarily, steady job, family responsibilities. Defense is basically saying, Judge, he's not a flight risk. He's a working man who made a mistake. But here's the tension. Deferred probation plus a new charge is always a red flag. Question for you. Should showing up and working full-time outweigh a pattern of driving violations?
Concern, and obviously it's something that, as the fugitive judge, to take into consideration. And you're right, this is our third time being before you. Unfortunately, I do know the matters in California have been resolved, and bond is supposed to ensure a person's appearance in court. Mr. Lewis has not had a problem with going to those states, appearing in court, coming back here as ordered by this court to show that he is handling his business. With this matter in Opelousas, this is a case that they just indicted. They sent the summons out. Apparently, he did not receive a summons. We had it on good authority yesterday that they were going to recall that and just reissue a new court date since it wasn't.
If they do
arraigned.
that, then that lifts the whole.
Then right, that solves
So,
everything.
I don't know if you can get over there and get them to say, hey, lift it, reissue it. Because if that happens, the whole releases, you make bond on the BMV and then
Correct.
he needs to
Correct.
do what he needs to do.
For the sake of, Judge, I would ask if the court would entertain a $30,000 bond, but if not, I do understand what my other alternative is, which might actually save him some money and do that. But I do want to be heard on that bond. And I would ask that bond be set at $30,000.
I can't. You scare me. And I tell you now, with me, I don't do it twice. It just, and now it's a third. Just not, I can't. You scare me, Mr. Lewis, really. All I want in life, all I want are my streets to be safe. Every single day, someone's dying around here. But one, I can't.
Thank you, Judge.
So, yeah, I mean, has he waived? Has he refused?
Yes, he waived on the 25th.
Okay, so he's got 1 day credit. I will tell you this. The good news for you is that we have so many buses coming in and out of Louisiana that if you make bond on the BMV case, you'll probably be back in Louisiana within the next 3 days. So the only thing that needs to happen, the problem is now we're told because he's not made bond on his misdemeanor case because it just got filed.
It just got filed, Judge, and we're
Make
working on that
bond.
now.
That lifts the toll. And then I'm telling you, we have buses in Louisiana coming to pick up people 2 times a week. So he'll be out, look at his plate, unless you can get that whole lift.
Yes, sir.
Your Honor, I will also note that he has an investigative hold prisoner hold. Jay did talk to me earlier that I should be gone before April, the next April setting of the other cases, but that is also holding him on extradition until the city.
An investigative hold for what?
It's
The
investigative
BMV?
hold prisoner. I don't know what it is off the top of my
So
head.
HPD has a hold on him for some reason. I have no idea. I've seen this maybe one time. It says literally investigative hold prisoner by HPD.
Okay.
have
They
no
only got
idea.
a certain amount of time. They got to either make, S to get off the pot. So we'll deal
I don't
with
know.
it.
I mean, your best bet, talk to Day because he'll tell you more what that means because I just don't know.
Okay.
He's already waived, so that part's done. Try to get the bond upstairs and then that way we can get.
Okay. Thank you, Judge. I'm gonna go back.
Thank you.
I have Mr. Jones back on docket. He did his TRAS.
Jones, which Jones? I don't-
Joshua Jones.
Oh, okay.
The TRAS came back. I think they recommended outpatient treatment. I believe so. Yes.
Okay.
They recommended outpatient with 2 open DWIs.
They recommended
Okay, so I'm gonna do it because I told you I would do whatever they do. But if he mucks it up, he's going into an inpatient. That'll be used as a sanction.
Okay. Will you take a year probation?
What do you think, State?
I'm sorry, I don't.
This is Jones, Joshua Jones. He has 2 open DWIs. Yeah.
I'm sorry, I tried to find that.
I think 2 years is appropriate so that we know.
Judge, you know what spot that puts me in. We can go to trial and get the same thing.
Okay. On 2? 15 months.
Okay, that's.
I'll talk to him.
It'll still be under. All
But
right, sounds good.
I don't know. He's gonna get tested a lot,
Yeah,
you know?
I will.
He's using.
No, he'll be back.
I guess. Judge, I think the assessment to have him go into physics is the move on.
What is the violation?
Alcohol and weed. I have done everything in my power to try to keep you out of custody. You have 2 open DWIs. I was now going to grant the fact that you had negotiated an intensive outpatient treatment. You now are testing positive for alcohol and marijuana while you're on bond for this case. And I have told you repeatedly that you are at no tolerance, Mr. Jones.
I don't do drugs. Period and point blank.
I have here,
Don't say anything. Can I get a copy of the bond violations before we discuss
Is it
it?
impending?
it's in ready for judge.
I don't know why it's not cool.
March 13th, the results were confirmed by the lab for alcohol and THC. Oh, wait. Joshua Dante Jones, right? Joshua Dante Jones?
It's just.
This has got, I don't know, something's wrong here.
I'm not understanding. I'm not saying.
Something's wrong.
Hey, case on judge.
Oh. We need to put pretrial services on probation, man.
I'm not sure.
I mean, it says here, Mr. Jones,
I don't see it in ready for judge.
no, it's wrong. It's wrong. Let me see it. It's wrong. Let me see. Yeah, it's wrong. It's a Joshua Dante.
Okay.
It's the exact same.
Okay.
You're good.
So we're good.
Hey,
It wasn't you. We're good.
that's not you.
Let's go talk again.
Sorry to scare you.
Judge.
Let's go talk.
He's good.
Judge, you stated this was in ready for judge?
Don't worry about it. Don't worry about it.
Was it an error on our end?
I want to apologize for getting mad at you. I had the wrong person, so it wasn't you. So I'm sorry for raising my voice and getting upset with you. And the reason I got so upset was because you have 2 open DWIs. It's serious business. It's not a, and so if I see someone that has those kind of cases that are open and when they start having more violations, that really tells me that there's a problem. which is not your case. I mean, I haven't seen any violations, which I'm hoping it stays that way. You know, the idea is that you learn something when you get here, so you leave better than you came, you know, because the last thing we want is for you to become a statistic. We have enough of that. We don't want any more. We don't want any more death on our streets. That's exactly what we're trying to prevent. And everything we do now here is to help you and give you the tools to make you better when you go out in the world, so that you think next time, you know, if you do want to get lit, right? If you want to have 32 shots of tequila, 52 joints, or whatever it may be, right? That you think before getting into a car. Because God forbid, it's that one mistake that you dig such a hole you never crawl out of. That's the idea, you know? You've worked a great deal here, really, where they're going to dismiss one of your DWIs. You're pleading to the other one. Nevertheless, when an officer pulls you over, the first thing they do, what do you think they do? They look at your record because they want to know who they're dealing with. If they look at your record and they go up to you in the car and they smell alcohol or dope, it's probably not going to go well. So the idea is, if you're going to get lit, if you're going to have that, be like that, take an Uber. Do you understand? The agreement that you worked out is, like I said, they're going to dismiss one of the DWIs. You're pleading guilty to one of the DWIs, so it will go on your record. You are now entering into an agreement, a plea bargain with the state. The agreement is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. You will do a TRAS with conditions. You have already done the TRAS. The TRAS has recommended intensive outpatient treatment, followed by supportive outpatient treatment, which is good. I'm telling you, I thought they were going to order you to do inpatient treatment. That's what I thought they were going to do. So this is great for you because you're not going into lockup. But understand, it's not easy. You have to get it done. If you don't, you understand. No drugs, no alcohol, no breath test refusal. So if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. Guardian interlock, a $100 one-time donation to Mothers Against Drunk Driving, and 25 hours of community service. I will make you a deal.
This is a huge moment. The judge gives him a PR bond, no money, but slams the door with conditions: drug testing, education requirements, GED pressure, and a total driving ban. Translation: I'm helping you, but I don't trust you. Do you think this judge is being fair or setting him up to fail?
Your license is now suspended. I had them look it up to see whether you can drive or not. You can't drive now because your license is suspended. It's suspended until 2026 as to what state saw and looked up. If you get your license back, I will waive that community service for you. I would rather you spend the time to try to get your license back and get liability insurance, car insurance. If you do, I'll take off the 25 hours of community service. You understand? If you fail at this agreement, I will issue a warrant for your arrest. I'm going to bring you back out. We're going to have a talk about whether you violated this probation. If you do, you're looking at 180 days in jail. You understand?
Stop.
The worst possible thing you can do is just take off. If you do, that's an instant warrant. The other worst possible thing, if you pick up another DWI. If you do, I'm just going to lose even more hair. Don't. Really. If you ever have a problem, come back, talk to us. We can always work it out. There's never nothing that we can't work out. Anything can be worked out. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense of driving while intoxicated?
Yes.
I'm going to find you guilty. I'm going to follow the agreement. I'm not going to suspend your license. It's already suspended because of the ALR hearing. So don't just start driving until you get it back. Because you don't have a license, we're going to order you to get a portable device. I've been paying for it now while you're on bond for this case. I can't pay for it any further. Reduce his fees, please. The other thing that you need to understand is DWI is big business. There's a $3,000 surcharge that one normally tack onto this. I'm going to take it off now. But from now on, you ever pick up another DWI, that's a second. From now on, it's a minimum of 30 days in jail and a $6,000 surcharge on a second DWI. Do you understand? All right. Good luck, sir. Thanks, Jimmy. You can wait now. Good morning, Ms. Whitaker. Ma'am, you are charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On September 4th, 2024, officers responded to an assault at In-Town Suites located at 9155 San Houston Highway in Harris County, Texas. This call was advised that the manager was pepper sprayed by the defendant. The complainant, the manager, was transported to Houston HCA Hospital, and the officer reviewed the lobby security footage and observed the defendant approach the complainant, becoming increasingly irate as they conversed. While the defendant was arguing with the complainant, the defendant grabbed a pink-colored pepper spray canister and discharged it at the complainant. The defendant quickly exited the lobby and fled the scene in a red-colored Mercedes-Benz. The complainant told the officers that she was working the front desk when the defendant came in, upset about her reservation, and demanded a refund. The complainant tried to explain to the defendant that she did not have the authority to issue a refund when the defendant pepper sprayed the complainant and ran off. The complainant positively identified the defendant through a photo array.
Okay. Ms. Whitaker, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons, and not to go back to this location. If I find that you violate these conditions, if you become a danger to my community, I only have one place for you. Do you understand, ma'am?
Yes.
I'm not asking for much. Do you mind filing those conditions, please?
Yes, Your Honor.
Do you have the ability to hire a lawyer, ma'am?
No, sir, I'm not working.
Okay, I'll have you fill out an application. I need to know everything about you, how much money you have in the bank, what kind of,
There's no money in the bank.
whether you drive a Mercedes-Benz, what.
It's in my daughter's name. She pays for it.
I need to know everything about you, ma'am.
You can know everything.
Deputy Miranda, do you mind giving an application? Do not leave until you sign our bond conditions, ma'am.
Judge, I'm sorry, there was one more. It's an off-docket arraignment. It's there next to you.
Okay.
I have Mr. Spence on your docket. He's present. The reason for the approach is I wanted to ask the court to consider modifying the MOEP or bond conditions for Mr. Spence. The complainant has communicated with the state that they're unopposed to the defendant and the complainant having contact, and that is the condition that we would like amended.
He's doing an online bib class. Does he have it done? Because once it gets done, the case gets dismissed and he's done.
You're absolutely right. This morning, he officially agreed to do the bib.
I have since January he's been working on it.
Well,
Given him more time in February. Now we're March 26th.
there was some communication with the state regarding which bib class to complete. That has been resolved. He's agreed to do it. It's a 16-hour online class.
I'm giving him 2 weeks. You know, really, we're now at 170 days. He doesn't have it done. Offer's been there since January.
I think we're okay with the 2 weeks, Judge. I just don't know how the court feels about amending the bond at this time.
Mr. Spence, come up.
And further background, there are some business transactions, legitimate business transactions between the complainant and the defendant, and they're both respecting the bond conditions and the MOEP, not having contact, but it's interfering with those business transactions, Judge.
Judge, we defer to the court. I will confirm everything defense has said.
Oh, you haven't confirmed it yet.
Well, no, I have confirmed it. I have been in contact with the complainant. She is asking to amend the bond conditions, but we would defer to the court to that ultimate decision.
Okay. Any prior assaultive history against the same complaining witness?
There is a prior assault of the same complainant. It
I'm
was
not going to do
dismissed.
it. No, he has a prior assault against this person that's just been dismissed. No. And I'm telling you now, your case is 170 days old. Since January, you've had an offer to have this case dismissed for you doing an online anger management course. You now have 2 weeks to get this thing done. If you don't have it done, I'm going to set your case for trial. Do you understand? Okay,
We'll get it done, Judge.
thanks.
Thank you, Judge.
Yeah, always a pleasure.
Likewise.
I'll get you. I'm reporting on Sierra Mitchell.
Mitchell. Oh, is it a new case?
So, no, what happened was I was her felony appointed lawyer upstairs.
Oh, did it get,
It got dismissed, but they refiled it as a misdemeanor. And so I've already talked to the MAC, and I was gonna request from the court that I'll be appointed as her MAC lawyer.
are you on the list to be appointed?
I am. I'm a MAC lawyer.
Already spoken with Morgan and she said she was fine as long as she got the green light from you.
I'm okay. Sure.
Okay, I'll make the request.
Yeah.
I'll just need your bar number when we're done.
Thank you for getting on our case.
No, no problem.
But we need to do bond conditions and
Yes,
stuff.
here's
It's an arraignment setting.
Right. Here's the PSR and we
Okay.
can follow up.
Ms. Mitchell, come up. Good morning, Ms. Mitchell. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. He has been gracious enough to now sign on to your case. He's doing it. So please.
On April 10th, 2024, the complainant stated that he got into an argument with his roommate, the defendant's boyfriend. The complainant stated the defendant scratched him while his arms were being held down by the defendant's boyfriend. After, the defendant used her forearm to put the complainant in a chokehold with her knee on the complainant's back. The complainant stated the chokehold lasted around 6 seconds and his breathing was short and it was painful to swallow. The defendant also stated to the complainant, "I'll kill you, ho." The officers observed visible injuries to the complainant's face, chest, arms, back, and shin. The complainant stated that the estimated level of pressure on the neck was a 10 out of 10.
Okay. Ms. Mitchell, do you know of any dope or alcohol, anything of this nature?
No, Judge.
Nothing alleged. No.
Ms. Mitchell, I'm going to find that there's sufficient probable cause to go forward with your case. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. I'm also now granting what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Sims as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this court order, they will file additional cases against you. A violation of protective order. It's one of the worst cases you can pick up. Because you have a lawyer, I will waive your appearance. But Ms. Mitchell, it is your responsibility to stay in touch with him. If he tells him he cannot get a hold of you because you're playing games, you've gone AWOL, you pick up a new case, you become a danger to my community, it's not going to go well for you. You will not get any more PR bonds. Do you understand?
Yes, sir.
Okay. So she has a prior, okay, the impeding breath is this case now.
Yes,
Do you
sir.
have any other
No
prior?
prior, no criminal history, Judge.
All right, I'm going to set your bond at $100 and I'm going to grant you a PR bond today. But like I said, this is the only one. If I find that you become a danger, it's just not going to go well. Do you understand that? Okay, I'm going to have you sign a reset with Victoria. We'll have you take a seat while we generate your bond conditions. Do not leave until you sign them. And after that, you'll be free to go.
Thank you,
Thanks.
Judge.
Mr. Chairman, raise your right hand, someone, please. Please someone certify that you've been convicted of a felony, namely, what's the aggravated robbery? In Texas, for 2000. And that you're reflecting the judge is out of the court, you don't use today.
Hey, Abigail, Abigail,
Yes.
need you with your computer.
Yes, absolutely. Sure.
See any other DWIs anywhere else, please?
All right. Can I get a cost number?
It's 253-9108.
Jones.
Okay. Mr. Jones, can you get your.
Not only that, can you run the license as well?
It's just these two for the
Nothing else?
GWS.
Okay.
And then prior.
And then the license, please.
Oh, the license, yes.
This is from a Facebook that you in this one, like, is one of the.
Okay, let me try.
It is suspended for ALR.
Okay.
The end date is
So say
2026.
the end date is when?
2026.
Okay.
So next February.
Press down.
Oh, and Your Honor, we have news for you. Kenzie and I are leaving on Monday.
No, really?
We are sad to go, but
Oh, where are you going?
keep an eye.
Okay. Where's she going?
Oh,
You know?
I don't remember.
Really? Awesome.
490 something.
One more time.
Maybe
Nice.
496.
So who, do we know we're getting 2 new people?
They're getting one host bar,
Okay.
whole, right near the conference. And then, and then you're getting John, he's one of our class, he's pretty good.
Okay, great.
One new, one old. And Blaze is staying. And Chief is
Stays,
staying.
right?
Yes, yeah, so. But new group.
Are you excited?
I am, I think so. I don't know a lot about juvenile, so I'll see how it goes.
It'll be a good learning
I
experience.
think so.
Yeah. Which court are you going to?
42nd,
Second.
Judge Nelson.
Okay, she's smart. She's good.
I've heard Amy to be very uncomfortable with it, so.
Just preparedness is everything,
Yes.
you know? Law, you know, because you're not gonna get all the, like, you'll get to really see what, you know? It's gonna be fun.
My parents say that my job is exciting now. I'm like, wait until next week.
I hope you have a good chief, because that really is what makes or breaks your, you know, because a lot of times, and I don't want to know, I don't know if you get to really do what you want to do, what your heart tells you to do, but I hope.
Hey, do you need anything from, Spears, Larson? Okay, you good? You good? Spears?
Thank you for the judge. Yeah.
Yeah. And it's been a good part.
Well,
But we'll be here till
you
Friday.
know, the idea is that it's easygoing, nice, fun, but it's stern when you need to be, you know? Who's the young lady in back?
Yeah.
The
Okay.
other one did.
Oh, that guy? Okay, got it. All right, coming up, guys. Mr. Jones,
You gave him that first grade.
Yes.